Vijay Kumar, 68.
My lords, I appear on behalf of the complainant, my lords.
Withdrawing.
Withdrawal, my lords.
Learned advocate for the complainant with so and so and so seeks permission to withdraw the present contempt petition, stating that the order is complied with.
No, my lords, on the basis of the assurance given by the respondents that they would, on the basis of the assurance given by
Then to withdraw the contempt petition upon instructions of the complainant.
my lords,
Dismissed as withdrawn.
my lords, liberty may be granted to revive the contempt petitions in the event that the respondents do not comply with, do not act on their assurance.
So then why you are withdrawing? They have complied with? They have complied with?
No, my lords, they've given an assurance that they would comply with the order, my lords.
Any future development adverse to the complainant will give press cause of action to the victim.
So number 69,
It goes without saying that any future. Yes. Yes,
RL and Murthy.
this is for.
The petitioner does not want to continue the case, my lord. So,
Learned advocate, Ms. So and so. What is your good name?
Minchu.
Stated that the petition, stated upon instructions that the petitioner is not inclined to, is not willing to continue with the presented petition and seeks permission to withdraw. If permission is granted, petition stand dismissed as withdrawn.
So number 31, so V Anand.
The kata of the property is transferred subject to the result of the suit, my lord. The suit is at page 127, my lord. Filed by the first respondent hearing for recovery of possession. Now, the arguments have been completed in this suit, my lord. We are awaiting the judgment, my lord.
Where?
For in trial court, my lord.
So you want time,
2 weeks time. my lord.
2 weeks.
Interim orders may
At
be
the
come.
request of learned parties, stand over to, we'll say 4th of July.
Please, my lord.
Interim order. Interim order is there.
This court said status quo, that by that time they matter listed before the court, Kata has been already transferred, my corporation counsel has
Now,
told
status
that
quo
he
is
has
there,
already
my lord.
informed. So for status quo is concerned, in the trial court also, he sought for an order regarding not to alienate. But I have undertaken that I will not alienate. That order is also operative. So will not be necessary to, for regarding the
orders may
status
be
quo of the,
extended.
kindly see what I
Whatever
have
order is, the
it is already
interim
there.
order operating in the
is on 16/12/23.
appeal shall continue to operate till the next day, whatever it's worth.
Minimum, I bring to notice of the court. Trial court has also already passed the.
Let, we will keep it on, not on July 4, but July 8.
Please.
That this may be noted, that Kata has been already transferred.
Pardon?
That Kata in respect to social property has been transferred in the name of the first respondent by the time this court has.
Status quo operating as on date shall operate.
That is what, let it be, because otherwise tomorrow it should not be
Status
taken
quo
that-
as
as
on today
yes.
shall continue to operate. Till the next.
So number 32, Anil Kumar S. L Siddhaya.
What is 32 years?
I am for the appellant, my lord.
What is it?
Appear for the third respondent, petitioner before the Honorable Single.
What is the matter? Yes? Please argue.
I am for the appellant, my lord.
Yes, yes.
The thing is, a notification was issued by the hospital authorities that is Atal Bihari Vajpayee Research Institute, calling for applications for the posts of professors and associate professors. And by keeping reservation, both vertical and as well as horizontal, to each and every cadre, not to the single post. Of different disciplines, they have called for the applications, reserving the post for horizontal as well as vertical reservations. In that, many people have applied, and the respondent 3 also was one of the candidates for the post. And he did not challenge with regard to the reservation policy while applying for that. And after selection process was over, provisional selection, there was an objection. For that, they said that according to the rules of reservation made by the government of Karnataka, we have reserved and selected the provisional selection list was published. And after that, final notification was also issued, final publication was issued, reserving the relation. That is being challenged with the thing.
So reservation is applied for single post.
Please.
Yes, single post, they claim that
That is your grievance.
and that is their grievance.
That is their
Single
grievance. Then
post.
their grievance is justified.
And my thing is, the different disciplines may be there. Each disciplines may be having one post, but all those disciplines together make one cadre. Together, all the disciplines together make one cadre. That is the thing, how the reservation policy has been formulated with the state government.
What is this view of the learned single judge, let us say?
Page 11, my lord.
One post of associate professor.
There are 6 posts of professors, my lord. Page number 37, may kindly see. Annexure D.
So in the notification dated 5th August 22, it was treated as a reserved post.
Lord, it was what had happened, Lord, that in the notification, they mentioned that the cadre is reserved. They did not mention which specific post is reserved. Draw your lordship's attention to page 41.
How does it help him?
No, it does not, Lord. That's what I'm saying.
Yes.
I got to know that my post was reserved only when the provisional selection list came out. At that point, I have raised objection. His case that I have not raised objection to the
There is
notification,
in a particular discipline, if there is a one post available,
please.
then the concept of cadre will merge with the
Yes,
post.
please, please.
Correct.
Precisely, Lord.
That's
That's the Lord law. The latest judgment in R.R. Inamdar is relied upon by the learned single judge. But my lord, even there are full court judgments of this court. There are many other judgments also, my lord.
Is it not, is it undisputed that the post of this professor of obstetrics and gynecology was only one post?
Only one post. It is undisputed.
One post where? In which department?
One post in the Department of Obstetrics and Gynecology, post of professor.
That is not a dispute, not disputed. Only one post
One post for that
in the
each,
department.
each discipline. There are 6 disciplines, my lord.
Departments,
Department.
faculties.
Department 1.
So what is the judgment? Inamdar, which is quoted by learned single judge.
Please, it is quoted. Page 15. In fact, page 14 of the appeal memo, para 10 onwards.
So concept of cadre, Mr. vanishes. And cadre presupposes plurality of the post. When there is one post, there is no concept of cadre. So even if they have mentioned the notification, when there is factually only one post available.
Not that, my lord. Kindly see Annexure N at page number 88.
What is that notification?
Annexure N at page number 88. Wherein the government of Karnataka
Notification dated 5th of August. Mr. Notification dated
No.
5th of
5th of August.
Notification law dated 5/8/22.
5/8/20. Yes, what are you showing?
Page number 88 may kindly be seen, Annexure N, my lord, wherein the policy of the state government has been clearly made. I shall read only 3 lines. Shall I read, my lord? Page number 88, Annexure N.
Page number
88.
88. Yes.
Annexure N, my lord. The order portion I shall read. This order is dated on 6th June 2005. In direct recruitment to the posts of professors, associate professors, and assistant professors in government medical colleges and medical colleges coming under the institutions registered under the Registration Act, falling under the Medical Educational Department, it is directed that professors, associate professors, and assistant professor posts should not be classified subject-wise.
This is contrary to the law, my lord, and I have challenged this
Whatever that
notification.
thing, this order has not at all been challenged in any of the ways till now.
It says that should be clubbed cadre wise, treating it as professor cadre. So if there is one post, then where is the question of clubbing and cadring?
And this particular notification has not at all been challenged since then.
What? This notification has no consequences in the effects of your case.
Because keeping reservation to all the backward classes according to the Article 14 and 16 of the
Mr. Counsel,
Constitution.
if there is only one pair post admittedly in a department, then the cadre concept will not come into picture. It will be a solitary post
As
without
per-
cadre.
No, no.
Cadre, if it can be said that cadre concept merges with the single post. Supreme Court says that it is.
That is
it has
not
to
the
be
criteria,
used
my lord.
different way.
That is not the criteria. But from the posts of professors, there will be promotion to the next cadre of director as well as the dean. Director cum dean is the promotional post from the posts of professors.
We are dealing with the.
Each department may not be considered as a
We are-
solitary post.
We are dealing with the reservation to a post, which is not in a cadre, because there is no cadre, because there is a solitary post, and therefore no reservation. That is the sum and substance of the.
No, nearly 26 posts of professors and 22 posts of assistant professors were called for. And all the posts have already been filled up. And no person have questioned this particular thing.
What was your challenge in the writ petition?
Lord, in the writ petition, the final
Wanted
selection
yourself
list,
to be selected.
final selection list, and my lord, this notification also which is being quoted was challenged.
So he was one of the contender.
He
To
was
the post.
selected, she was selected.
She was
The-
selected,
Please,
Yes.
but then what happened?
Lord, she was in the final select list. After reservation being extended, I was the most meritorious candidate. I challenged the final selection list before this.
You challenge the.
Please.
Your petition.
Please,
This Vijay Kumar is respondent here in the appeal.
please.
On the ground that this reservation.
It is
can't
a
be-
single post, please.
Sorry. Appeal is dismissed. Not to be written.
Great.
This is number 33, from Manmohan PN.
Here for the appellant counsel.
Respondent.
No report.
Yes.
My lord, appellant is running an engineering college. We have, my lord, several courses. One of them is B automobile engineering and B industrial production engineering. B automobile engineering.
Other is.
Another is, my lord, B industrial production engineering. Third is, my lord, mechanical engineering. All these, my lord, are in BE, Bachelor of Engineering. What happened was, my lord, over the years, the demand came down, 254, my lord, page 254, if your lordships come to. Though we had, sorry, 254, my lord. Automobile engineering, our intake, my lord, as per the AICTE is 60. Over the, my lord, 50, it was increased to 60 from 2017-18. From 48, my lord, it fell down to 35, and my lord, in 2020-21, it became 4.
Page 250.
254, my lord.
250. Yes.
If your lordship sees, my lord, the
So
first
this
one,
is,
B,
intake is gone down.
yes, my lord. Went down to, my lord, 4. So it was impossible to, my lord, go on with the The department, my lord, we sought permission of the AICT, university, my lord, both of them, my lord, gave us permission to close that department. Page 245 and 246 are, my lord, the orders of, my lord, the university as well as AICTE.
So all three departments were closed.
My lord, the first one was closed. The automobile engineering was closed. Mechanical, my lord, we have still there, but it has gone down, my lord, drastically. We will be, my lord, I don't know, maybe in another 2 years, because everybody is informal, my lord, going for computerization, AI, all that kind of thing. Yeah. Correct. Even mechanical, as your lordship sees, my lord, from
Automobile is also nobody preparing.
on the contrary, my lord, law colleges, my lord, people are now coming more. We are happy.
Then what happened?
We, my lord, closed down, my lord, the department. As a result of which, my lord, the respondent before your lordships, first respondent, was, my lord, relieved. He was a professor, my lord, in the automobile engineering. My lord, he is specialized in automobile engineering. Therefore, my lord, we can't fit him in anywhere. So we issued, my lord, a relieving letter. Page 240 is the relieving letter. My lord, 245, if your lordships come to, my lord, for the closure of this department, we took, my lord, the permission of the university which gave us permission, 245. Visheshwaraya Technological University, my lord, VTU, is the university, my lord, to which we are affiliated. Then, my lord, the All India Council of Technical Education, AICT, is page 246. They also, my lord, granted us permission to close this department.
Page 2.
246.
So AICT also granted.
At 247, my lords get that, my lord. At 247, 246 it starts. 247. Absolute bottom, my lord, my lords get that. (246) at 247 bottom, my lord. Engineering and Technology, undergraduate automobile engineering, approved. Courses applied for closure by the institution for that academic year 2021-22. Other one is, my lord, engineering, industrial production also, my lord. We didn't have sufficient people. Therefore, my lord, there's a second appeal before my lords. The that's the second one, my lord, where engineering production, my lord, industrial production and production engineering was also closed. So, my lord, he filed a writ petition. First respondent before your lordships and the first respondent in the other writ petition, my lord, appeal. They filed the writ petition before my lords. The writ petition, my lord, their prayer is for a mandamus to, my lord, not to terminate them because, my lord, the closure of the department. Honorable Supreme Court, this Honorable Court division bench has specifically held that, my lord, the closure of, my lord, the department is, my lord, the prerogative of the employer or the institution, and the courts will not interfere. That's a first submission would be, my lord, against this is a private institution. It is not an unaided institution. Therefore, my lord, writ is not maintainable. Latest judgment is, my lord,
Justice Paradiwala said.
2023, 4 years CC, my lord, 498. Mary's, St. Mary's Education Society, writ is not maintainable. Nodi kottirbeku.
Same judgment you are referring.
Yes, my lord. But Justice Pardiwala's, my lord. Absolutely. Secondly, my lord, Supreme Court, my lord, division bench of this honorable court as well as the Supreme Court have time and again held, if a department, my lord, post is abolished,
That is also a judgment. Where is that judgment?
my lord, I have kept it. my
But
lord,
here
for my-
post is not abolished.
Post is abolished, my lord.
Post is
Post is abolished, department is abolished, both.
So it may be a more nearer judgment. for
Yes.
the
My
Abolition
lord,
of
the
post.
division bench judgment of this honorable court, my lords get that at, my lord, running page
No, this is
44,
Private,
private, my lord. This is a private body.
not aided.
No, my lord.
Particular department. Even if it is aided, then what?
Then also same thing, my lord.
Same thing because it's
Yes,
service,
yes.
service dispute.
Correct. And
Yes, so what is the next?
learned single judge holds,
Expression of opinion.
That much we can.
learned single judge, my lord, holds. The judgments have quoted, my lord, relates to, my lord, temporary post, which also is not correct. Can I persuade your lords to look at, my lord, the judgment that I have given to my lords? The division bench judgment at, my lord, page 44. 44. In fact, learned single judge has virtually created a post, my lord, which doesn't exist. 44, my lord, if your lords has come to. Please come to para 5 at page 45, my lord. Paragraph 5. Respondent was appointed as the assistant instructor in canning and food preservation on 5th of March 1969, Foodcraft Institute, Mysore Society. 2 teachers were working in the Department of Canning and Food Production. Teaching staff have a minimum of 760 teaching hours in a year. During the year 89 and 89-90, there were no students for canning and food preservation course. In the result, 2 members of the teaching staff were idle without any teaching work. In view of this, by memorandum dated 6th of September 1989, Society resolved to abolish canning and food preservation courses. Consequently, respondent who was holding the post and another teacher were relieved of their duties. Agreed by the same, my lord, they filed a writ petition. If my lords come to, my lord, paragraph, my lord, 11 on the next page. Para 11, my lord. The judgment of the Supreme Court in Ramanath Pillai versus State of Kerala AR 1973 SC 2641 is an authority to state that the power to create or abolish a post is a matter of policy. Power to create and abolish a post is invested in every employer, whether the employer is a state employer or a private employer. And such power should be conceded to an employer in the interest of necessity, in the interest and necessity of internal administration. Creation of abolition of a post is dictated by the policy decision, exigencies of the circumstances, administrative necessity. Creation, continuation, and abolition of posts are all decided by the employer in the interest of administration, general public, if such employer happens to be the state employer, and in the interest of exigencies of administration, if such employer happens to be a private employer. Whether the post should be retained or abolished is essentially a matter for the authority to decide. Abolition of a post is an executive policy decision. Then, my lord, it is not open to the court to go behind the wisdom of the decision and substitute its own opinion for that of the authority on the point as to whether a post should or should not be abolished. The only requirement is decision to abolish this post should be taken in good faith and not be used as a cloak or a pretense to terminate the service of a person holding the post. Then, my lord, para 13, 1-3 on the, sorry, para 13 on the, my lord, last second column, bottom. A public servant enters into an appointment to a post on the understanding that he is entitled to hold it so long as the post is in existence and not abolished. His right at the highest is to continue in the post so long as the post continues. But he cannot,
The
but we cannot,
abolition of post cannot be terminated,
yes,
equated to them.
yes, yes. And para 14, if your lords has come to 1, 2, 3, 4, my lord, the abolition of post may have consequences of termination of service of a public servant. Such termination is not dismissal or removal. Therefore, opportunity of showing cause against the proposed penalty of dismissal or removal does not arise in the case of abolition of post. The abolition of post is not a personal penalty against a public servant. Right to hold a post automatically comes to an end on the abolition of the said post, which a public servant holds. Honorable Supreme Court judgment, my lord, my lords, get that. So, next page, my lord, at page 50. 1973, 2 SCC.
That is same which was referred.
My lord, same. In fact, if my lords come to my lord, paragraph 36 at page 60. Say, my lord, what has been culled out? Para 36 has been culled out there, my lord, by the division bench of this honorable court. Para 36, page 60, my lord.
It starts at page 50.
Yes, my lord.
And para 36.
Yes, ma'am.
Yes.
Para 36, the abolition of post may have some consequence of termination of service of a government servant. Such termination is not dismissal or removal within the meaning of Article 311. Opportunity showing cause against a proposed penalty or dismissal or removal does not therefore arise in the case of abolition of post. Abolition of post is not a personal penalty against a government servant. Abolition of post is an executive policy decision. Then, my lord, para 39 also, my lord, says, right to hold post comes to an end the moment, my lord, there is an abolition of the post. Therefore, my lord, he can't complain of violation of Article 19(1) for Article 31 of the Constitution. My lord, please come to, my lord, the next judgment at page 65. 65. Yeah. This is, my lord, 2007, 1 SCC 408. The lords may come to, my lord, page 83, para 37, my lord. Para 37 at 83, page 83. Creation. Sorry, my lord, it starts at 65 at 83.
Executive function.
Yes, my lord. Creation and abolition of posts and regulations are purely administrative functions. Hence, the court cannot create a post where none exists. In this case, my lord, the single judge has virtually done that.
Which paragraph?
Para 36, my lord. 37, sorry, 37, page 83, my lord.
Yes.
Creation and abolition of posts and regularization are purely executive functions. Wide P.U. Joshi versus Accountant General. That is, my lord, 2003, 2 SCC 632. Hence, the court cannot create a post where none exists. Also, we cannot issue any direction to absorb the respondents or continue them in service.
But termination upon abolition of post will attract some kind of rights or not?
No, my lord. That's what, my lord, the Supreme Court has held.
That is
Therefore, my lord, 4-0, my lord, on the same.
only condition that it should be borne up.
That's of course, my lord, absolutely. In fact, para 40 of the very judgment at the next page, my lord, their lordships have held, page 84. Same judgment with para 37 I read, para 40 at the bottom, my lord. Courts must therefore exercise judicial restraint, not encroach into the executive or legislative domain. Orders of creation of posts, appointment of these posts, regularization, fixing of pay scales, continuation in service, promotions, etc. are all executive or legislative functions. And it's highly improper for judges to step into this sphere, except in a rare and exceptional case. Relevant case law and philosophy of the judicial restraint has been laid down by the Madras High Court in so on so on. There are two other judgments, my lord, I don't want. First judgment, my lord, with regard to Justice Paradiwalas is the first judgment, my lord. Page 3. (2023) 4 SCC, my lord, 498. My lords may come to, my lord, paragraph 75, my lord, at page 42. Final conclusion, my lord, has been set out. Starts at 3, at, my lord, page 42.
This is same in the 226.
Yes, my lord. Yes.
So page?
Page, my lord, 42. An application 75.1, my lord. Application under 226 of the Constitution is maintainable against a person or a body discharging public duties or public function. Public duty cast may be either statutory or otherwise, where it is otherwise, the body or person must be shown to owe that duty and obligations public involving public law element. Similarly, for those, for ascertaining the discharge of public function, it must be established that the body or person who was seeking to achieve the same for collective benefit of the public or a section of it and the authorities to do so must be accepted by the public. Then 75.2, my lord. Even if it is assumed that an educational institution is imparting public duty, act complaint must have a nexus.
Service dispute is not.
Absolutely, absolutely. That's all. Therefore, my lord, my submission is that the learned single judge has. Paragraph 50 of the impugned judgment, my lord, if your lordship just have a look at it.
So
my lord.
what was the prayer before the learned?
Learned single judge, my lord, he has held, my lord, issue a mandamus, my lord, to not to terminate. Page 95, my lord, if your lordship come to 95. Issue a writ of mandamus restraining fourth respondent from terminating the service of petition on the ground of closure of the department. Then certiorari to quash the impugned resolution. Resolution, my lord, was passed by the, sorry, page 95, my lord. Sorry.
This resolution of.
Resolution of the board, my lord, board of the
Dispensing with the services.
institution.
Resolution to dispense with the services.
Yes.
Now what weight with the learned single judge?
My lord, he says, the judge, my lord, he doesn't go into, my lord, that whether, my lord, a private institution, my lord, writ is maintainable or not, despite raising it, he has not answered it at all. Secondly, he says, the judgments with the abolition of post, those where, my lord, judgments were all temporary post, my lord, it is not. In fact, can I persuade your lordships, just look at, my lord, the order.
No. So judgment which says that the department was closed. And
Yes.
consequently, the. one
Not
has to
only
be-
that, my lord, the first judgment, that division bench judgment of this honorable court, it's not a temporary post. Please come to, my lord, page 44.
All other temporary post.
Please, my lord.
All other judgments are in relation to temporary post.
In respect, no, we submitted 4 judgments. 2 were, my lord, temporary, yes, I agree. 2 others are not. One, my lord, of this honorable court, division bench. Another of the Supreme Court, it's a 2008. Please come to, my lord, that judgment. If my lords come to, my lord, 2008, page 90. It's not a temporary post. 90. 2008, 2 SCC. My lord, please come to para 3 on 91, page 91. The respondent herein was appointed as accounts executive in the Haryana Public Service Bureau of Public Service Enterprises on 16/7/93. While so continuing, his services were terminated and so on. So on the ground that the post accounts has been abolished. So, my lord, that's not a temporary post. Para 17, if your lordships come to. That's okay. That's the same. Page 95, para 17, my lord. They've culled out, my lord, the principle. Page 95, para 17, the power to create, we summarize the power of the government in abolishing post and role of court for interference. Power to create or abolish a post rests with the government. Whether a particular post is necessary is a matter depending upon the exigencies of the situation and administrative necessity. Creation and abolition of post is purely government policy, of a matter of government policy, and every sovereign government has this power in the interest and necessity of internal administration. Creation, continuation, and abolition of posts are all decided by the government in the interest of administration and general public. Court would be the least competent in the face of scanty material to decide whether the government acted honestly in creating the post, refusing to create a post, or its decisions suffer from malafide. In this case, my lord, we went before the university. University said, yes, my lord, virtually 4 students. We can't have, my lord, a full department. And the other one also, my lord, is similar effect, where, my lord, it came to, my lord, I think some single digit. Therefore, my lord, we had to close.
How many years of service he had put in?
My lord, He has put in 1 minute. I'll just tell you.
But he will be getting the retirement dues. The kind of.
2005, my lord.
Nothing.
Just been shown the door.
You've shown the door. So that is, in that context only we are asking that anything attaches, any kind of right attaches, nothing.
No, my lord.
That's
Quickly, my lord, what happens is we are an educational institution.
person's long service of 20-25
My lord,
goes.
he is a PhD. He can always go somewhere else, my lord.
50, my lord.
Automobile engineer. There are today, my lord, the cars. My lords are aware, my lord. Cars have increased, my lord, so much. Every household has, my lord, 2 cars today. Therefore,
Every household has
2 cars, my lord. 2 cars,
cars.
at least in the cities. We see, my lord, I remember, my lord, years back, some 25 years back, I went to Greece. All over, my lord, the road, my lord, on both sides, they are parked. Today, my lord, we see it in Bangalore itself, my lord. There's no parking place. And, my lord, we are an educational institution. We run, my lord, from,
But if you terminate him in such a manner,
my lord, what choice do we have, my lord?
where he would park himself in life,
Yes, my lord, work for 25 years, my lord.
parking place in the life also.
All that is there, my lord, I entirely agree.
Yeah.
But
To
we,
send him high and dry like anything, that is not, that doesn't, that.
no,
doesn't-
I understand what my lord is
This
passing
is-
on in your lord's mind.
That is the only.
Only difficulty is, my lord, the court, my lord, the courts have time and again held, my lord, that. And, my lord, what do we do? We are educational institution.
What court can do, Mr. Panin?
Lords, I'll just show. My lords, when they went to VTU, they have accommodated others, my lords.
There you can accommodate, yes.
No, everyone who was in mechanical, they have accommodated, they had passed a resolution. Please come, what they applied to VTU, my lords, when they asked for NOC, please come to page 245 minutes. I'm sorry, 292 minutes. For the NOC. That's a university to which they are applied, my lords.
$290.
292 minutes. It was applied. Lords, the application was filed on 7th of April 21. The next day NOC is given by the VTU.
All non-teaching staff will be accommodated.
Then,
In
my lords,
other-
in case of please see 3 and 4, they had constituted a committee, and this was, my lords, given on 7th of April. They informed the VTU, we have constituted a committee. In case of teaching staff, Honorable Chairman so-and-so has issued orders to constitute committee under the chairmanship of so-and-so and members as so-and-so. The committee will go through possibilities of accommodating teaching staff on a case-to-case basis and recommend to the Board of Governors for needful. Committee report. This was on 7th April.
Yeah.
Now NOC is given on 8th April, your lordship saw at page 245. In that, please see the bottom, my lords, 245. On 8th April, VTU gives it. After the chart, clause 2, my lords. Current staff strength rearrangement and dues, if any, shall be settled as per existing norms and regulations. On that behalf, liabilities, if any, on this count shall be the sole responsibility of the applicant of the society and shall be settled. This no objection is issued subject to pending approval of Academic Senate, Executive Council and Government of Karnataka. Whoever, my lords, for the NOC for closure. Now, my lords, they took this. The VTU also said this will be subject to the decision by the Government of Karnataka. Now, we don't have any, they have accepted this. Now, my lords, on 7th, they said, we will accommodate these people. Now, the committee's report your lordships would get, which they constituted, at page 289. Please come to the report at 289. Committee's report on 12/1. 10th May 2021, which they had informed VTU that we have constituted a committee. There the committee recommended, please see, my lords, they take into consideration how others are being transferred and accommodated in other branches. Because the other course, it's been increasing the students count. Then they said, committee recommended to transfer following 5 faculty members of automobile engineering to mechanical engineering. One is, my lords, the first one is the first respondent herein, Ravi Shankar. And the 4th person is in the connected matter, he is the person.
There was one mistake.
10, my lords.
My lord, since my learned friend is on this page, it's a aided, mechanical engineering is aided by the government. Now we have stated that in our objection statement. That's one mistake.
Then, my lords, at page 290. Your lordship should get the heading mechanical engineering at 290, my lords. The committee noted PG admission is less than 10 last 3 years and hence advised to review admission of existing PG program and submit a report before December 2021 by the department. Required number of faculty 38, number of faculty available at present 30, number of additional faculty required 8. This will be met by transferring the faculty from I&P and automobile engineering. Now for others, they have accommodated, your lordship should get the chart, my lords, at 186 annexure S. From automobile, they have put them into other courses. It's not that end. Please come to 186, my lords. Their own chart.
Clearly the PR idರಲ್ಲಿ. ಅದು interim order.
But this is type copy is not clear. There are some blanks, but we have the other copy.
So they're accommodated elsewhere.
Well, in the same college, my lords. From 97, we have been, one of them is working from 97, he is 52. Lords, if you show the door and send him out, my lords. And they went to VTU, my lords, VTU gave them the permission within 1 day because they told VTU will be accommodating them. There is a committee. Then what they do is they constitute another committee, a second committee which says relieve. ಇದರಲ್ಲೂ blank ಇದೆ. Some of them from automobile and industrial production, my lords, they have been transferred to computer science, mechanical. That annexure S reflects that.
Yes, sir. Yes, sir. Whatever, you know.
Because, my lords, what's happened, annexure S, when Xerox has been made,
Correct.
certain things have come blank. Oh, that's how, my lords, I have made. Adu mistake agagirodu. Annexure S alli nimdralli. The columns. These columns have come blank. We have, my lords, the original reads like this.
It is a statement showing the accommodation of.
Yes, yes. Those have come blank because, my lord, sometimes computer printouts go blank. That's all, my lords. My lords.
So he is
And in fact, when
15 years of service.
My lords, one has been working from,
Any precedence in form of judgment what you submit?
my lords, what we showed, my lords, if you lot,
Namely that they should be accommodated.
they have to be accommodated. One, my lords, Bombay High Court, of course, says
Bombay Court is-
judgments. We had produced it before, the learned single judge has referred to it. In fact, we also relied on St. Mary's, that is, my lords. Then the earlier judgments which showed the teaching posts are actually, my lords, a public duty.
No. That is the direction where the court says that they deserve to be accommodated,
My lords,
notwithstanding the closure of the department.
my lords, Bombay High Court has dealt with it. Now the issue is pending before the Honorable Supreme Court. My lords, your lordships would get serial number 8 from serial number 6, 8 and 9. My lords. And serial number 7 judgment, my lords. Closure of college itself, the court has taken a view that financial viability cannot be a excuse for it. I've given the para numbers and the proposition.
That is a different.
Disagree against the judgment of the.
The closure of close and the course, my lords. College also. The lordships.
Payment of approved compensation.
And if the learned single judge no doubt holds, my lords. He has considered that aspect, saying that, yes, it's an absolute right. But Ramanath Pillai, my lord, the division bench of this honorable court relied on Ramanath Pillai of the Supreme Court. Ramanath Pillai case was one, if your lordship sees, it was a case of temporary appointments. There the honorable Supreme Court holds the petitioner knew that it was a temporary post. In so far as, my lords, the other judgment which was relied upon by my learned friend, that's in the case of Institute of Hotel Management, that's a division bench judgment. Here, my lords, the institute itself, my lords, closed the course. It's not the college which closed the course. It's like if your lordship kindly come to 44, my lords, running page 44. That is, my lords, the division bench judgment of this honorable court. In the case.
Yes.
If your lordship sees at para 2, my lords, towards the end, last 5 lines, what is National Council for Hotel Management is a registered autonomous society set up by Government of India. Then, my lords, please see para 4. The NCHM in its meeting held on 25th 89 resolved to phase out the courses of canning and food preservation in all institutes. The first petitioner is affiliated to NCHM and it can only conduct the courses which are recognized by NCHM. In view of the decision of NCHM, petitioners were required to abolish the courses in canning and food preservation. There, my lords, the regulating authority itself wanted certain courses to be abolished or closed. That is not the case here. And the division bench relied on Ramnath Pillai, my lords, at para 11. The lordship sees the learned single judge's order.
This High Court judgment, it was not a temporary post.
No.
Not.
Of this court, this High Court.
No.
So the principle applies.
No, what? Yes, my lords, but there the division bench only relied on Ramanath Pillai to arrive at that conclusion. Whereas Ramanath Pillai, if your lordship sees Ramanath Pillai for a moment, my lords, your lordships would get at running page 50 in that compilation. In that, if your lordship kindly come to, my lords, Ramanath Pillai starts from page 50. at running page 52. At page 52, para 4, if your lordship sees. The facts in civil appeal, it starts, your lordship gets it. My lords. In civil appeal are this: a vigilance commission was constituted for state of Kerala by an order dated.
Post for a period of.
Yes. Thereafter, again, it goes at para 8. By an order dated February 24th, 1970, Government of Kerala stated post of Vigilance Commissioner sanctioned was temporary, and the present sanction was for the post of Vigilance Commissioner will expire and so on. So. Then, my lords, at para 10, their lordships again considered that. Para 10 at running page 54, last 3 lines therein, my lords, in para 10. The appointment of members was of a temporary character. Consequent upon abolition of the board, there existed no post on which the appellants could claim appointment. In this case, the learned single judge has considered all these aspects. The learned single judge says, no doubt it is a right for them, but also says under the AICT regulations, it permits closure of clause, but it does not say what the consequence of a closure of course, whether they should be accommodated elsewhere. And he has also relied on the resolutions passed by the institute as also, my lords, accommodating others. Now my position also, my lords, if your lordship sees the precarious position which we are placed at 120 at J1, we had also obtained a housing loan based on the NOC given by the college. Where I was shown what my retirement would be.
You put in 15 years of.
From 97, my lords, 97. One petitioner is from 97. The other petitioner is from 2005. That's recorded by the learned single judge. And the learned single judge has taken that into record. That having, we have given our youth to them. Today, my lords, in our 50s, in fact, when they apply for rating of the institute, after this litigation, they show us as regular employees.
So to page 289, other names who are there are accommodated.
There. That's avrellaru accommodate agidara.
289.
My lords, I'll just. He's been accommodated by interim order. My lords, I'm told. Or the interim order. Lords, I'm told Shashidhar is working based on an interim order. Then the other 2, my lords, I'll have to find out. But there are others, my lords, whom they have accommodated. Annexure S, which we have shown, the chart.
Which
we have, my lords, we have a memo along. Lords,
all are accommodated.
most of them, lords, we have produced, we have prepared a memo showing that how many people from automobile and industrial production, where they have accommodated to everyone.
So in this automobile also there.
We are from, yes, automobile also.
We are dealing with the
automobile. Automobile and industrial production also, they say they are closing. Oh, they have accommodated most of them. Not most, my lords, almost everyone. We have the biodatas of all those people whom they have accommodated.
Mr. Holla, why should there be heart burning?
My lord, what has happened is, as far as this is concerned, my lord, let me again, take instructions and see what it is. What has happened is, wherever it was possible, we have accommodated them. For him, my lord, it is just not possible, 2 of them. Therefore, they are before your lordships. My submission is, my lord, even the order, my lord, of before the AICT when we went, they said, wherever it is possible, we will do.
So in this automobile, how many were relieved?
My lord, automobile, I don't know. My learned friend has this. What is, he only prepared this. Next is yours.
Sir, Phanindra, you kindly get prepared the chart.
Yes,
the person.
Let me, yes.
In addition to this, only name.
I understand.
the details
Yes,
With
where they have been accommodated.
in the context, with their total tenure and where they are accommodated.
Please, my lords, we'll do
My
that.
lord,
And
Bombay,
also whether they belong to automobile department.
Automobile to, yes, we'll do that.
Then Mr.
Bombay judgment,
Huh.
AACT refused permission, notwithstanding that they closed it. Therefore, my lord, can please come to my lord that Bombay judgment at running page 169.
Now we are flying.
And I
above-
leave it at that. I don't want to, my lord,
Now
go into.
flying
Very well,
above-
very well. My lord, I bow down. What is passing on in the lordship's mind, I understand. After all, it's a human problem. Let me, my lord, again, my lord, talk to them, find out.
In some
whether it-
matters, we fly above judgment.
Please, my lord. My lord, have I ever said no, my lord, to what falls from the court, and especially
Fine,
in this kind of a
please.
situation?
We are not concluding anything, but this
Very
is
well.
the-
Please, my lord, will also.
the first,
We'll-
there are two matters.
Two matters, my lords, two.
Two of them.
Take your own time, but just.
Yes, ma'am. We'll, my lord, I'll also talk to them and then find out. No, no, no.
89 and 98. When shall we? Whenever you want. Take it.
After 2 weeks. After 2 weeks, my lord, we'll also, my lord, I'll also get them
I'll
and then.
also
try
Get the date, 2 weeks will be when? 3rd February, 3rd July,
to- Please, ma'am. 3rd of
3rd
July.
July.
Interim order to continue, whatever is the. interim.
10th order to 3rd July, interim order granted earlier shall continue.
Please.
You are not in service.
No,
No pay on this. Literally, bank is virtually, my lords, getting into, I am being declared as a NPA now for my house. Lords, I have taken a housing loan based on their NOC.
like, in 2013.
Oh, but my
13.
retirement age was shown.
Okay, anyway, it's all right.
Will-
Let me say.
It's a house that I am trying to save. That's why.
If there is nothing serious, Mr. Holla, against him, then
I'll, my
kindly
lord, I'll.
find out a way.
Only difficulty is, my lord, I don't.
You are
know.
the right person to find out.
They told me, I know, my lord, it's our duty also. After all, my lord, when a human being, my lord, if he is now thrown out, but he went and told the AACT and, my lord, made some complaints and all that, we were downgraded, I believe. That's what, my lord, they say. Just find
I'll
out.
find.
And talk to him not to do this.
So in
All that,
that-
my lord, we'll, my
Lords,
lord,
if
I'll check up on
learned
it.
senior told me, I'll find out, my lords, if that is the
If
case,
that aspect to be settled, you may settle the way
Lords,
they want.
please. Before that, before it comes.
Please.
December 35. Shri S.B. Mukanappa.
The appellant Maladi was a retired employee of the corporation. The respondent after his retirement, the corporation has paid the gratuity in sum of rupees 8,19,628 rupees. As against Malad, the 10,97,668 rupees. Malad, thereafter, Malad, the appellant has approached the controlling authority, that means the third respondent. The third respondent must pass an order and also direct the respondent, respondent corporation to have to pay the difference of gratuity amount. Thereafter, the corporations filed the appeal. In appellate authority also, they confirmed the order passed by this controlling authority. Thereafter, the first respondent has filed this writ petition before the Honorable Court, challenge the order passed by the third respondent and also second respondent. The Honorable Single Judge, the allowed the writ petition filed by the first respondent corporation. The corporation has pay the payment of gratuity, my lord. The only the calculated, my lord, the only the period of 30 years, 2 months, my lord. But my lord, according to us, my lord, the was served over a period of 40 years of 4 months, my lord. That's why, my lord, the respondent corporation has to pay the 2,76,228 of rupees, my lord, the arrears of gratuity, my lord. That's why, my lord, the controlling authority and as well as appellate authority has passed an order, my lord, direct the respondent corporation to pay the difference of gratuity with together 10% interest, my lord. My lord, the was joined the duty, my lord, the on 4/2/1976, my lord. My lord, the annexure A, my lord, itself says, my lord, the kindly wanna see the page number 28.
Now, where is the order in writ appeal number 717721?
That has not been produced, my lord. My
Produce
lord,
it.
kindly wanna see the annexures.
That will solve your issue.
The
whenever
page-
it's solved. This reinstatement was with continuity or press?
Continuity of service.
Then this.
My lord, the page number,
Single is not right.
page number 17, my lord. Kindly permit me to read.
Then you are right. But provided you produce the order. Page
Page number 17, my lord. The
17.
honorable single judge, my lord, the paragraph 6, my lord.
Why? That is what we are asking. Therefore only we are asking that if this
My lord,
order
the-
of this court in the.
My lord, the
earlier petition-
corporation has to
So we have
produce.
to see the language of the operative portion. In what way you were reinstated at that time? You get, it will be available.
He was continuous service, my lord, from 76 to 1986. That's why, my lord, the annexure A, my lord, itself says, my lord, the annexure A, my lord, the page number 28, my lord. He has worked, my lord, 14/6/80 to 19/3/1980. And as well as, my lord, annexure B itself says, my lord, the kindly wanna see the annexure B, my lord. 33, my lord. He was terminated from the service on 10/11/1980. Annexure C also, my lord, the serial number 1 LG Satyanarayana. 30/4/1986, he reported duty.
You are Satyanarayana,
Yes, ma'am, the serial number 1, ma'am.
3486.
LG Satyanarayana, 30/4/1986. My lord, these documents, it shows, my lord, he was,
76 to 86 also you work.
yes, 86, my lord.
From 76 to 86 what?
My lord, it means, my lord, the documents, it shows, my lord, in this period, my lord, he was appointed 1976, my lord. Thereafter, my lord, in 86 and 80 also he was working. That's why, my lord, that it shows, my lord, the he was worked continuous service from 76 to 80.
Refreshment. No.
The- This is after it. the findings given by the controlling authority in page number 54, my lord. The exhibit P1. Page number 54, my lord.
54.
The answer to issue number 2, my lord, the page number 54, my lord, the order passed by the controlling authority, that is the translated copies of the English, my lord, the page number 54, my lord, the answer to issue number 2. The applicant has joined the respondent corporation on 4/2/1976 and retired from service on 30th/6/2006. Page number 54, my lord.
So what is that 54?
Page number 54, my lord, the portion of the translated.
What is it? Answer to number 1.
Issue number 2.
Issue number-
The applicant has joined the respondent corporation on 4/2/1976 and retired from service on 30th/6/2016. The respondent have stated that the applicant joined the service of corporation on 30th/4/1986 and retired from service 30th/6/2016. The applicant is support of his statement as produced exhibit P1 from the said record. It is known that the applicant was appointed in the service of the respondent corporation on 4/2/1976. Since the said document is the document of the respondent corporation, it is said that the applicant joined the service of the respondent corporation on 4/2/1976 and retired from service on 30th/6/2016. Therefore, the applicant has rendered his service from 4/2/1976 to 30th/6/2016 for a total period of 40 years, 4 months of the continuous service in the respondent corporation. Therefore, the applicant is eligible to receive the gratuity for this period. The applicant has last drawn basic pay of 27,170 and the respondent stated that the last drawn basic pay of the applicant was 27,170 and dear length allowance 9,781. Hence, it is confirmed that the last basic pay of the applicant is 27,170 and dear length allowance 9th. So the gratuity. The exhibit P1, the document is the respondent corporation document.
So what were these writ petitions
The writ petition filed by the corporation.
and pursuant to which by order dated 35/86 you were taken back in service?
Yes,
That order is at page 35. That order shows that you were appointed again. What happened in between? Between 1976 and 1986, some event took place whereby your services were terminated. What was that event? You are not disclosing that.
that is the exhibit P1,
You are harping that the services are continuous, but that is not fortified, rather it is contradicted by page 35. So you have to enlighten us whether your services were snapped between 76 and 86 any point of time.
the 8 is.
That link is not two. Removed from service,
Yeah.
in 80.
Removed on the 30th/4/1986. 86. So until date, he was worked on continuously.
Removed on?
Removed on 30th/4/1986, page number 35, the annexure C.
वो तो, हाँ?
The page number 35, annexure C. He was,
Appointment letter.
yes. 31/5/1986, he
Yes,
was
it's
reported.
appointed.
State 4, as per annexure C.
You can only produce the order in writ appeal number 17721, writ petition number, whatever. To show that you are
That
reinstated with continuance.
But my lord, that contention, my lord, taken by the respondent corporation, they have to produce that copy, my lord, my lord.
You are asserting your.
I agreed, my lord, but my lord, they have not take any contention before the controlling authority and as well as the appellate authority.
Select 1980. Oh, that is first one. It is all that. Yes, what? So you, that is over. Sir, you produce the order. We are telling from the beginning. It is your, in your interest, if you try. Order of this court whereby your client was reinstated. If it is with continuity, then you are entirely right. If you are not, then this order will sustain. So get the, it is a matter of
I will-
record, get the order.
I will get the.
You get it.
I will get.
So that if you are right, then you are not
Yes.
wrongly punished.
Right.
Right? When?
3 weeks,
3 weeks will not.
2 weeks.
2 weeks will.
Much.
Second of. Otherwise, there is no. It appears to be no case. Your appointment was fresh appointment. As per page 35. And as observed by the learned single judge also. But still we are giving you a chance. Second.
I will.
Shall we keep it at 2:30, Mr. Counsel? At 2:30? At 2:30.
So government appeal, 36.
My lords, in this matter, I have paid Okalat for respondent, my lords. I may be permitted to represent my lords.
So you condone the delay of 17 days.
May be
Or
condoned.
learned additional advocate, additional government advocate, Ms. Neelo Akbar for the applicant and learned advocate, Mr. So-and-so. Ada
Adavishaya, my lords. Adavishaya, my lords.
Respondent. This is order in IA, 1 of 24. It is to condone the delay of 17 days, which has occurred in filing this writ appeal, which is prayed to be condoned by filing this application. The supporting affidavit spells out the reasons which led to passage of time, resulting into delay to the extent of 17 days. Full stop. It was due to administrative reasons and the time consumed in the decision-making process that the delay has occurred. Sufficient cause is made out, delay is condoned, application is allowed. So it will go to some other date. 1st of July.
Much obliged, my lords.
Number 37, Mr. Subramanya R.
For the appellant. Lord, I pray for a short accommodation, Lord, in this case. Lord,
This is that doctrine of pleasure.
doctrine of pleasure, my Lord. In
So
this case, my Lord,
let us wait.
short date may be given. Any day, my Lord, in
Date will be given.
next week, my Lord,
Next
any-
week.
please. Lord, interim order may be continued till then.
27th of 28th of June.
Please.
This is short date. Next week. Well, 19th,
Please,
19th June.
Lord, interim order may be continued till then.
Interim order already granted and operating shall continue to operate till the next. So this is which law is there?
Lord, here is a case, my lord, doctrine of Central Relief Committee, my lord.
Which
It's
committee?
under
Which committee?
This is the act which was enacted in the year 1975, my lord, and it's specific to the state of Karnataka that helps to protect, rehabilitate the beggars of the state of Karnataka. And therefore, there is a committee that is constituted under this act. And in that, there are 4 permanent members and 4 nominee members. Among the nominee members, there is 1 chairperson. Now, the petitioner herein is the appellant herein is the chairperson nominated. And the question is whether the tenure is, there's a doctrine of pleasure operating on the tenure. And they seek that it is an appointment as a chairperson and therefore they have the right as a
19th
chairperson to
building.
continue for 3 years.
Lord, here is a case. Please,
19th.
read.
$56 OBs के साथ में 19.
56 also. So number 38. Tanisha L.
Affidavit dated 6/6/24 is not served on me. Affidavit dated 6/6/24 is not served on me.
You comply with it within 2 weeks. Yes, next.
So number 39.
My lords, I'm appearing for the complainant in this matter, my lords. My lords, this contempt is
Gentlemen.
pertaining to the accused wherein he changed the name of the, changed my name and replaced it with the government's name, my lords. Wherein the writ court has allowed my writ petition, and despite the same, I have placed my representation.
Whatever you comply, 2 weeks.
Date,
Date will be given 4th of July in both cases.
my lords, on the last occasion, this court had directed the accused to be present physically before this court.
But then you comply, we don't want presence, you comply with the order, let us see what is it.
My lords, I filed a memo on 4th of June, my lords.
Where are the directions to be complied with?
My lords, a memo has been filed on 4th of June, my lords, along with the single bench order.
Which order you are calling in question? In
My
contempt?
lords, order dated 22/1/2024.
That
my
is
lords.
interim order, interim order.
Yes, my lords. Initially, the contempt was filed on the interim order, my lords, wherein and thereafter the writ came to be disposed, my lords. It came to be allowed.
It was stated that pursuant to order dated 22/4/14. Who is present?
All right, during the pendency of the interim order, my name was removed from the revenue records and.
Where is that order to remain him, ask to requiring him remain present? By which, under which order? Directed to, yes. Yes. Both the respondents are present? Both are present? By what, pursuant to, in view of the order dated 22/4/24. Right again, it was stated at the outset that by, that in light of order dated 22/4/24, respondent accused named, what is the name? So and so holding the post of Tehsildar is personally present. The presence of the respondent is recorded. Full stop. Learned additional government advocate, Mr. Jafar, assures the court that steps will be taken before the next date to to comply with the directions. To be listed on 4th of July. Presence of the respondent is dispensed with unless specifically directed in future.
Publish.
Number 40 to Venugopal MS.
I have filed the application, my lords. It is not, today I have filed the application, my lords. It may be ordered to be listed next week, my lords.
Which application is?
Impleading application, my lords, impleading the proper party.
In contempt?
My lords, there is an order by the earlier court, my lords.
The first accused, my lords, has
8th of
retired.
8th of July.
Please.
His place is bringing the new officer. First accused has retired on June 30th, 2023.
So he is impleading whom?
The current
Then
incumbent,
of
my lords.
Number 41.
This case I have to complaint.
Ms. Chandrasekhar.
This is in respect of annexure A, my lords, in page number.
Complied with?
No, not complaint. my
Not
lords.
complied.
This
Who
is in respect.
Page?
No, no, writ appeal was filed subsequent to the contempt was filed, my lords.
Which page?
Page number.
Hmm?
Page number 50.
Directed to
16
reconsider
minutes.
the representation.
Representation was given, my lords.
Considered.
No, no, not considerably. It is not,
So why you are not?
I have filed,
complying with such order? Directed to reconsider the representation. Same order?
no, no, my lord, your lordship kindly have a look at.
Which order you want to
Annexure,
Which order you want to comply with?
annexure A, my lords.
Page?
Page number 16, my lords.
Same, page 20, no? Last period.
Last,
So in the
page number
response
20,
four
last.
is directed to reconsider the representation and pass order appropriate. What is the representation?
What happened, my lords, earlier point of time, pensionary benefits was, there was the directions. You know, 247A, my lords, there were two government orders. 1982 and
Pension.
2 and 13, my lords. Para, your lordship can look at para.
At this
8
stage,
of
we are
the-
not patient enough to.
Well, it requires some consideration. I'm ready, my lords. My lords, in page number 16, my lord, I request my lords to have
At
a
this
look at.
point of time, we are not patient. We have no patience to listen to a story. You answer what is it, pension, that's all.
No,
When you will comply with?
No, no, it's not compliant, my lords.
Comply with.
It is not compliance, my lord. My-
It is complied with.
Your lordship can look at the page number 16, my lords, para 6, my lords. I request your lordship to. This is in respect of 247A. In the other matter, it is not questioned. WP, this writ petition was not challenged and interim or not granted in this case, my lords.
Not completed 30 years. No pensionable service.
No pensionable. He is aged about 79 years, my lords. And
He's
he is
old, right?
from past 20 years running from pillar to post, my lords. In the year 2015 itself, you had to have filed contempt.
10 years old. There you make him sit. Why you are keeping him standing? He should sit down and take
I
rest.
am sorry, I have not
That's right.
seen. Lordship, I request your lordship to
On one
look
hand,
at.
you are saying that 79 years and you are keeping him standing.
I'm sorry.
Both those don't go together.
Like in page number 16, my lords.
See compliance. He needed to serve minimum 10 years.
That has been, your lordship kindly have a look at page 16 of my annexure A, my lords. Para 6 minutes. It is clearly stated that
Page 16.
page 16 minutes. It is not in this, I read it.
Page 16 is what?
Yeah,
Part of the order?
part of the,
Yes.
the operative portion minutes. The applicants have already submitted representations to the concerned Tahsildar with service records requesting to sanction pension, and the Tahsildar have not yet forwarded the pension papers without proper calculations. The Accountant General
has not considered the latest government order 26/4/2013.
How much service he rendered?
He has rendered 8.5 years, my lords. He is in view of this government order, he is
So
entitled for
what
10
is-
years of service.
What is the period condonable?
1.5 years, that's all. 1 year, 6 months is the difference, my lord. That's all.
They give, they condone one year and a half, 6 months.
Hmm.
Let us see, where is the circular?
That's no. This order speaks. There was a government order.
Order does speak, but where is that circular which is spoken of? No? Give circular. If correction of the deficiency is condonable, we'll condone it.
Yeah, and as per the government order, my lord, sir.
Give the order, please, sir.
It is placed on record in the earlier
That we
proceedings,
don't
my
know,
lord,
we
sir.
don't.
I will produce, my lord.
Produce it. When will produce?
I will produce, my lord, sir.
When?
Next week, my lord.
Next week. That's the whole point. Learned advocate, Mr. So-and-so, seeks to produce government order dated 26/4/13 to submit that by virtue of the said order, the deficiency in qualifying service, which is alleged by the respondent, is condonable, even if there is a deficiency. Full stop. Stand over to 19th of July, 19th of,
Next week, my lord, 20th or
that is what we are saying. Tell the date, 24th of June. Monday, 24th June.
much.
Number 42. Venkatraman Reddy.
Similar, in identical matter, this honorable taken a view that against the interim order application may be moved. And again,
Mr.
at that-
Jaffer, if it is a fresh matter, we follow the course which we adopt. But if notice is received and you have filed reply, taken stand, then we are slow to dismiss on the ground of interim. Because
they have not filed our reply.
they have not filed,
They have not filed.
not filed.
And in similar matter,
What is where is the order? Let us see.
Annexure C, page 27.
Order of this dispossession till next date of year.
This protection is granted since the impugned order does not mention about the participation of survey personnel from the revenue department. And in spite of order, your lords may kindly see the next annexure D series. Annexure D series.
That is what I said. I'll come.
No, my lords,
Which matter?
my lords, I am aware of that. Your lords may against that.
Where is? We recollect the same photograph. Same photograph.
No, my lord.
Scattered mangoes.
That is on merit. Now the, in spite of interim order, during the midnight, is like Britishers, they entered land at midnight and dispossessed removed the 40 years trace.
There is a direction from earlier bench, so. Yes, next. 17th of July. 18th of June, yes. Next.
Number 43.
Lordships, I appear for complainant.
Yes.
Lordship, all the respondents of the government, in fact, the government is directed to take notice and I have served the copy to the government. And now they have put, the compliance has been done, but it is not done, your lordships. That is the only instruction from my client is that the partial compliance where they have only removed the bund and they have not removed the private road which has been put up by encroaching the land. So I may be permitted to file a rejoinder. And I am not served with the compliance affidavit, Your Honor.
So copied, learned advocate appearing for the complainant made a grievance that the copy of the compliance report is not served to her. Responding to this, learned additional government advocate, Mr. Jaffer, stated that the copy of the compliance affidavit shall be given to the learned advocate within 1 week, stand over to 2nd July.
Great.
44. So Sharon Desai, party in person.
I appear for the first respondent in this case.
What is this? Public interest survives for perennial time, but public interest petition will serve for only 1 year. So what survives in this matter? What is this, Mr. Count, Mr. Party in person?
My lord, this matter is regarding Kalburgi Fort. Kalburgi Fort, which has been illegally encroached by the citizens of Kalburgi. My lord, 282 structures are in the inside the fort, which are in protected area, and 62 are prohibited area, and 114 in a regulated area. The order has been already issued in 2019 to clear all of them, but since the state is buying the time to rehabilitate them somewhere else, but since 5 years they have not done it.
It's for the state, my lord. State has to rehabilitate
with
them
regard
or
to the
make some
rehabil-
arrangements for them, my lord.
This, you
With
have to
regard-
rehabilitate some person.
Please, my
Please.
lord. Otherwise, they'll have to vacate the encroachment. My lord. That is the only ground, my lord.
They are encroachers.
Please, my lord.
In fact, there is an
Why
order.
why encroachers should be rehabilitated?
Lord, that was the stand taken by the state, and that is the reason, my lord, that the matter was urgent time to time, that they'll rehabilitate them. If your lordship may kindly see, my lord, about 282 violators are there in the protected area.
That is inside
and
the fort, my lord.
Inside the fort.
My lord, in this matter, the state
Not today,
needs to.
13th will take.
Great.
13th,
Much obliged.
13th.
My lord, if a accommodation may be afforded, because I need to file a report as to what has happened and what rehabilitation measures.
It's a 6-year-old.
Please, my lord,
this has
I
been-
understand. I
this
want
has
to
been the
file
same
a
statement from
status.
last 5 years, my lord.
Hmm.
This is the same statement provided by the state from last 5 years.
No, we'll see first on 13th what can be done, 13th of June. Then we'll, if necessary, we'll grant time.
Please, my lord,
On
please.
13th, you ready with your response, because this can't sustain for 6 years.
Please, please, please.
Much obliged, my
Much
lord.
You know, how you can go on prolonging the matter?
My lord, I cannot, I
Because
stay
you
in.
are party in person.
I'm appearing every date, my lord, since 2018. Thank you, my lord.
Great.
Much obliged.
Case number 45. Abhinav Ramanandye.
Was appointed not to assist the court with the help of technical experts not to take up restoration of not the lake. But the technical experts not require some more time not because they have to visit the lake not and make a survey, which may grant not about 2 weeks time not.
2 weeks time. It will go to 15th of, it can do 15th of July.
Very well.
Case number 46.
Please, my lord.
My lords, in
Item 46, my
item
lord, I had
46.
mentioned this matter, my lord, morning.
I have
Since I am coming,
46.
please, my lord, since I am coming from Delhi, my lord, in the month of
I
March
have
also.
one submission to make, my lords.
Page number 153, operating portion.
So his matter, whose matter? You are the, you
My
are
lords.
the.
I am for the respondents, my lord, we are for the respondents.
I am for the
That is-
corporation, my lords.
Read
I
what is
appear
the
for the
petitioners?
corporation. I have one submission to make, my lords. I am the appellant in item number 46.5. My lords, what has happened is that, my lords, in my appeal, my lords, initially, my lords, there was a direction by this honorable court. After BK Pavitra's 2, my lords, there was a seniority list prepared as per BK Pavitra 2's judgment, my lords. That list was under challenge by the respondents. Now, my lords, what has happened is that, my lords, when the other appellants filed the writ appeal before this honorable court, there was a direction not to publish a seniority list by this honorable court, my lords, in these proceedings. Now, my lords, what has happened is that, my lords, I'm not seeking for any modification. I'm only seeking permission from this court, my lords. Because of that, my lords, we have stalled all promotions. As on today, my lords, the entire organization, because of this proceedings, my lords, there's 1,600 and odd posts vacant. And my lords, due to the weather condition now, my lords, after trees are fallen and all of that, we are unable to even have supervision staff, my lords. I may be permitted to only produce one document before my lords.
My lord, with great
Therefore,
respect, my lord, they comply with the
my-
learned single
my-
judgment, my lord.
my only
My lord,
submission,
in this case, my lord, sorry, my lord, in this case, my lord,
my
the
only
judgment-
submission,
The
I'll just-
judgment attains finality, my lord. So the judgment rendered by the Honorable Supreme Court, my lord, in Narayanan, Sadasiv Rao, and the judgment passed by the division bench of this Honorable Court in Guru Silpad, my lord, that attains finality, my lord.
Let me
So the
complete-
directions given should be complied with, my lord. That is only issue.
My respectful submission is this, my lords, let the matter be heard at length. But meanwhile, my lords, on in-charge basis as a temporary measure, my lords, let me fill up the post as per the current seniority, subject to the outcome of this petition. Subject to the outcome, my lords, I'll undertake that.
Today an interim order is operating.
No,
Yes,
no,
I
that-
filed
no.
an application, IA number 2, my lords, is there before my lords in item number 46.5. IA number
No-
2
no
for that,
copy- no
but
copy
my
has
lords,
been
that
served
is,
upon us, my lord. And my lord, if they are facing any difficulty, my lord, they should comply with the judgment of the learned single judge subject to the outcome of
that
the
is under
judgment
challenge.
passed by the division bench. A well-reasoned judgment of the learned single judge, my lord.
My
Why
lords,
they are scared of?
I may be permitted to place this before my lords. My lords, kindly, as on today, my lords, the organization is unable to function because of the vacant posts that are there.
Lords, our submissions, lords, that despite the direction, lords, of the Honorable Supreme Court in K. Narayanan's case, lords, and subsequent judgments, that, lords, the persons who come, lords, to the cadre on a subsequent date, lords, they cannot be placed above us.
This will consume time.
Please, my lord.
Yes, my lords, and that my only submission is this.
They cannot
But
take
meanwhile, my
advantage of,
lords,
lords, the
I'm
fact
not,
that-
it will not prejudice their rights.
No, no.
It will not prejudice the other appellants' rights. As a corporation, my lords, I'm not on their side or this side. I'm only saying,
Carrying further, we will not grant any order or no modification.
My lord, from our side, my lord, the.
only to
the
say, my
petition-
lords, the
From our
posts may
side,
be
my lord,
filled
the
on
engineers are
in-charge
retiring.
basis, subject to the outcome of this petition, my lords.
No,
They
no,
will
no.
be put in, if their
They should
if their
comply with
right
the
is
judgment of the
enshrined, my
learned single
lords.
judge.
The middle, we will not grant such a, in a very lazy manner, the interim.
And my lord, my lord, they should comply with the learned of single judge, my lord, subject to the outcome of the writ appeal. What is harm in it? Why they are running away
There
from
is-
complying with the
No,
judgment of the
as
learned
regards
single-
that, my lords, there is merits. I have my submissions on that, my lords. They are not, it is not on that. It is not on that. It is on the notifications by this, before this honorable court.
So when shall we keep? All problem is because you are coming from Delhi.
Please, my lord.
My lord.
And every time, my lord, with great respect, my lord, every time I am.
Then my respectful submission. Then
My submission is, my lord,
Welcome, but because of presence, the matter is not proceeding.
I will not come, my lord. I will not come, my lord.
No, you problem. When
I
shall-
had, my lord, I had given a suggestion that your lordships may fix at 2:30. Then at least, my lord, the hearing may start, my lord. My lord, the 3rd or 4th July, my lord.
4th July.
My lords,
At
anytime,
2:30, my lord.
3rd July.
anytime
2:30,
this,
my lord.
2:30.
my lords, anytime this month, I may request, my lords, it can be disposed of anytime this month. We are ready to at least hear it on merits. my lords. This month, anytime, if my learned friend can accommodate anytime this month, my lords.
Let it be listed on 4th or 3rd, my lord, doesn't matter. But kindly see one direction of the honorable judge. But
3rd at
the-
2:30, my lord.
But the administration is totally paralyzed today. But there are,
Not at 2:30, but in the session beginning at 2:30.
Please, my lord. Same thing, my lord.
but meanwhile,
We'll
but
take up
me-
since council is coming from Delhi. We'll.
it's all right. But let the mat, but
Heard of, you just, who is local, you are the local council.
Please, my lord.
Just remind us a day before.
But can there, but interim. But can there be an interim, my lord, direction to the corporation, my lord? But for this reason, why I am developed, there are, my lord, about 15 posts of chief engineers remain unfilled. My lord, totally, my lord, the administration is paralyzed because of the,
My lord,
kindly see
they- my
the
lord, the
direction,
judgment-
last direction.
Order is operating.
No,
He
no
can't,
interim
but-
order.
Order is operating.
But they will also be the beneficiaries.
Not
Even the writ petitioners are the beneficiaries. Kindly take page number 153 in my
They
writ
lost
appeal.
they lost
Kindly
before
see the
learned single judge,
direction.
my lord.
In course of the hearing today, learned advocate, Mr. What is your good name?
Devdas Senior.
Devdas, presses for interim relief. In the facts of the case, interim relief cannot be granted, it is refused, more particularly when no interim is granted at the initial stage. However, at the request of learned advocate, so and so, so and so, put
No
upon
interim.
3rd of July.
Obliged, my lord.
Want this order? No.
That is the interim. Your lordship may say till the next date of hearing, because the
First
my
matter,
lord, next
first
date,
item-
my lord, when your lordships will have time, my lords, your lordship may, my lord, we may be able to pursue your lordship, my lord, to consider our,
You have got one matter, we have got 65 matters.
no, that is reason, my lords, that is,
Necessary, we are not willing to waste time.
I am not here to, my
We are
lord,
not granting any interim relief, Mr. Counsel.
please, my lord.
Unnecessarily don't go on making submissions
Very well.
for sake of making it. You know that it is not of any worth. Yes, next.
Obliged.
3rd July.
Seal number 47.
I appeal for the appellant in this case, my lord. Some time may kindly be granted to comply with the.
Yes.
I need to pay the process, my lord.
All office objections, 3 weeks time is there.
Please, my lord, please.
48, not to be placed in 48, not to be placed before. All interim order will be extended.
My lords, still number 49, my lords, so it has written answer to respect to certain respondents and then granted time to furnish the office of
All 3 weeks.
interim order candidate.
All.
My lord, serial number 55.7, my
Interim
lords.
order are operating will be extended without pension.
My lords, serial number 55.7. In fact, there was a small office objection on the wakalat. I represent R15 in this, respondent number 13, sorry. And earlier, there was a GP holder who was representing the case. Now the R13 himself is signed the wakalat and he will be appearing himself, my lord. So I kindly consider the office objection being complied, my lord. There's a objection on the wakalat.
File wakalat now.
Yeah, it's filed, my lords.
What is difficult?
So now that, the objection to be complied here has 55.7.
File copy.
My lords, serial number
Yes, my
15,
lords.
59, all the office objections have been complied, but it is
Complied with. Learned advocate, Mr. So-and-so states that all the officers are complied with. In that way, it will be open for the registry to list the matter for admission hearing at the earliest.
Sorry for making this, in seal number 46, not just now concluded. There is an interim order till date, that may be extended.
If it is there, it will be extended.
Yes.
My lords, kindly, serial number 67 was specifically listed today, my lords, because of the construction being deteriorating, my lords, some accommodation, my lords, at 2:30 on any day convenient to the honorable
You are
court.
not clear to us.
My lord, serial number 67, my lords.
Not
Construction.
So what do you want?
Construction is deteriorating. My lords had fixed it today, especially before vacation, it had come up. Some accommodation at 2:30 on any day convenient to the court. Otherwise, it will not reach, my lords. Construction is.
Yes, give some date. Yes.